Hello, everybody. My name is Grace Kolodziej. I'm with Chicago Title, and it is so hot in Chicago today. It's even hotter because we got the Northwest Side Preservation Ordinance happening. So excited because I'm here with Jim Erwin to talk about it.
Good morning. Jim Erwin with Erwin Law. We're based on the north side of the city. Been doing real estate law for just over 30 years now, and our firm also does litigation and estate planning, but today we're dealing with the real estate industry.
So, Jim, what was the goal behind the city implementing the Northwest Side Preservation Ordinance in the 606 area?
The goal was to, as it kind of says, preserve affordable housing, and what they're focused on is naturally occurring for affordable housing. And essentially the difference between naturally occurring affordable housing and anything else is what is basically legally mandated affordable housing. For developers often to get rights to build certain projects, they have to include an affordable housing component. The focus here on this ordinance is to preserve naturally occurring affordable housing, multi-unit properties, and the focus is in these areas. The 606 ordinance is being expanded through this new Northwest Side Housing Preservation Ordinance to include essentially 5 wards.
Can you give us a general breakdown of the timeline a real estate agent would need if they were planning to list a property in that affected area, like the intent to sell, waivers, just a general time frame?
Sure. So it's broken down into essentially 3 phases. There's the notice of intent to sell phase, then there's the right of first refusal phase, and then if you get to it, the closing phase. Agents, brokers need to be very aware of this. It requires a lot of planning. The initial notice of intent to sell phase is either 30 days or 60 days, depending on the size of the property, and then the right of first refusal phase lasts 90, 30, or 15 days, depending on the size of the property, larger to smaller. And then the closing period is 120 or 60, depending on it. So you're looking at an overall, for a 5+ unit building, you're looking at a period of time that can stretch over 9 months. So you have to be aware of that. Going into it, the brokers need to particularly be aware of that initial notice of intent to sell phase because it has to come before anything that they do.
The Department of Housing is issuing a statement of compliance. Can you talk about this and explain what the lead times people can expect are?
Therein lies a little bit of the problem. The ordinance itself doesn't say that DOH, Department of Housing, has to issue these, what we're loosely calling certificates of compliance. In practice, however, as the ordinance rolled out and we started sending notices into DOH was responding pretty quickly. Initial experience, first weeks of March, was 1 to 2 weeks, which was great because that could, depending on the circumstances, cut your initial hold period time down to 7 or 14. Very important for the timeline on these contracts. Of late, DOH has fallen way behind. I think there was essentially one person responding to them. They've said that they're hiring specifically for this, but when I alluded to part of the problem, those emails that we were getting back certifying compliance, there's only so much weight you can put on that. They're helpful, but because the ordinance doesn't specifically say that DOH even has the authority necessarily to determine that, there are some title issues to talk about.
So I think one thing that we're coming into right now is that they'll get a certificate of compliance and think that that's all that is needed for the closing or to be cleared to close. But I'd like to ask you, what else and what other steps would someone have to go through after the certificate of compliance and then reach out to the title company?
So in a perfect world, because you can't fix prior mistakes too easily, I'm telling people, A, don't wait till you get a certificate of compliance. Don't rely on it. The ultimate gatekeeper here is going to be you folks with the title companies. You know, we'll talk in a minute about lender issues related to it, but all of this is going to come down to getting title clearance, showing the title company that you've complied with the requirements of the ordinance. You know, the hold period that I talked about, that first notice of intent period, those 30 days or 60 days need to pass before you can list or go under contract. Very often we're seeing agents not aware of this, listing, getting a contract, and then trying to comply. You're already out of compliance, and theoretically you have to go back, and not theoretically, you have to go back, delist or cancel the contract. So it's important to know about it in advance. With this ordinance, until we start to really figure it out, get comfortable with it, brokers need to just ask. I recommend going to an attorney in this case, or at least contact your title rep. Find out, what do you need, what is the list, and can I provide it? It includes photos of posting of the notice at the building. So really got to know your stuff before you start any of this process.
Does the right of first refusal apply to short-term renters?
So while the ordinance itself applies to all rental properties within the zone, and that includes room sharing rentals, things like that, non-conforming basement units or attic units, if you have a tenant in there and you have a month-to-month or written lease, it applies. But the rules specifically state that rentals through an online platform, short-term rentals like Airbnb or other such platforms, are exempt.
Have you come across any situations yet where the tenants have exercised their right? And if so, what was it like? And at what point do the tenants need to provide financial assurance if requested by the owner? On
the deals I've done so far, we haven't yet had any tenants exercise their right of first refusal. It's a little challenging, just like on our side, and by our side I mean the real estate industry side. Tenants are still learning about this and trying to figure out how they would even exercise their right. And it is a little challenging for buildings with 3 units or more. They have to actually form a tenant association. There's a formal process by which they have to do that. They have to have a representative speaking for their group. So as of yet, I haven't experienced it, but it's also part of, I like to think, the planning process that I've been trying to coach people that I work with through both sellers and agents, and that planning process. And that is, while the ordinance says that during the hold period or before that, you cannot request that a tenant waive their right, nor can you require it. There is nothing to prevent you discussing this ordinance with your tenants in advance and telling them, hey, here's what's happening. There is a new ordinance. You're going to have the right. I have to give you certain notices, or I am giving you these notices. If you have any questions about it, you can contact DOH. You can ask me. And they're right there on the initial form that you give to the tenant, that you file with DOH. There's a waiver opportunity for them. Again, you cannot request it, nor can you require it. But if they wish to waive it, if they say, I have no interest in doing all of this, sharing my information with my neighbors, whatever, they can waive it. Through that sort of education process, we've gotten a lot of the tenants to waive initially, at least enough that the building then is essentially exempt from further portions of the ordinance. So your question about financial assurances, you can't require any of it until you get to the second phase, which is the right of first refusal phase. At that point, if they decide they want to exercise their right of first refusal, they have to, along with their notice of exercising it, in the case of less than 5 units, they have to present a pre-approval letter from a financial institution, from a lender, and 5 units or more, they have to provide a particular form of letter of intent. You also have to remember, no matter what the contract says that you have with a third party, as far as earnest money, you cannot collect more than 5% from a tenant association or tenants that want to exercise their right.
You were recently featured in Crane's Chicago Business Magazine. One of the issues that was mentioned is that Fannie Mae will not insure or underwrite properties that have the right of first refusal. Is this creating a problem with financing on these transactions, and how are you specifically handling this?
It's true. There's been a lot of talk in the last few weeks. That was one of the more recent kind of unintended consequences that we were experiencing. Fannie Mae was not going to underwrite any loans in the zone because they won't underwrite with a right of first refusal. However, it does appear that you can get it so long as the title company will issue an endorsement over it. So again, it's all about prepare in advance. Talk to your attorney, talk to your title rep, make sure that A, they will issue the endorsement. What will it take to get the endorsement? There is a fee associated with it, so you have to know all of that going into it.
So it sounds like it's extremely important to have a support system behind you when you're dealing with these types of transactions. On a scale of 1 to 10, how important would it be for the realtor, the attorney, the title company, and the lender all to be aware of this situation and know how to handle it?
In this case, it's imperative. Again, you make a mistake, and depending on where you made the mistake, it could cost you months. And as we know, buyers aren't going to typically hang around for months, particularly because in this case, what this ordinance has also done is to knock out 1031 buyers from the pool. You have to prepare, you have to know in advance. Typical residential real estate deals, we're not involved until the contract's signed. I'm really trying to counsel agents against that in this case. Really just make sure it's buttoned up.
As a title company, we want to ensure that once a property closes, that there is no legal issues for the next ownership, which means we have raised exceptions on title. Can you explain how this exception might affect the work that is done and needed for closing?
Sure, we've touched on this a bit already, but in a lot of the industry, the title company is kind of just this necessary evil, right? But it's important for parties to understand that what the title company is doing is issuing insurance policies to the owners and to the lenders if there's a lender involved, and they need to ensure that somebody's not going to come back and attack title. It makes perfect sense. The concern here in this ordinance is that it does leave the back door open for a private cause of action from tenants, tenant association, third parties could raise a claim. And so, again, it's important to know what the title companies are going to require as in terms of proof, and it goes beyond anything in the ordinance. The title companies have a separate list of requirements, photos showing that you did post the notice of intent at the building as is required under the ordinance, but there's nothing in the ordinance that says you need to take a photo of it. You're going to have to be able to prove it. Proof that you supplied the notices to DOH and to the tenants. Even if your property is not a rental property, it's owner occupied, 2 flat, you live in one apartment, the other is vacant. Technically, that's not a rental property under the ordinance, but the title company doesn't know that. They're going to need proof. Some require an affidavit, whatever it is. It's just best if you get the list in advance, prepare, you know it, so you're not trying to fix a mistake afterwards that you can't really fix.
Based on what you're seeing from these transactions, what is one recommendation or piece of advice you would offer to either a landlord selling in this area or a real estate agent representing landlords that are selling in this area?
Said it before, prepare. Not to beat a dead horse, but in this case, let's say you're the owner of a building. This is unlike any other transaction that you've done before. This is a completely different landscape. Best to not figure you're going to get around it. Best to not figure cut corners, none of that. The best way to save time on this, and again, for a 5+ unit property, can stretch 9 months or longer. For larger properties, I'm telling landlords, talk to me in advance. There are strategies I can offer, not to cut corners, but to plan in advance to shorten that time. You can do things legally, but you can't do it retroactively. Once you've set your foot in, you may have already messed up. So it's talk to your team in advance, talk to your lender, find out what they know about this, how they handle it. Do they have any issues with it? What are they seeing? I'm not seeing everything. I only see it from my perspective and those deals that I'm going through. If you even think you're going to sell next year, start that conversation. Get your documentation in order. Think about your tenants. One thing to think about is a vacant building. You don't have any tenants to waive the right of first refusal. It shortens the timeline automatically. It's all about planning for the process.
Have you come across any issues with realtors that have not known about this issue and they were not aware of the timeline and you had to be the one to break it to them?
Yes, to the latter, unfortunately. We had one particular example recently where an agent represented their client on the sale in Portage Park area, and then their client said, help me with a buy. They moved over a few neighborhoods and wound up in the zone, and the agent had no idea and went under contract, and the seller on that property didn't know, and I had to break it to them that we have to undo this. From the buy side, I know already that it's not going to clear, and I don't want to take that chance, and I don't want my buyer sitting around for 4 months only to find that it can't.
In your professional opinion, how important is it for a real estate agent to be educated on this topic, even if they don't farm this area?
So for those that say, this doesn't affect me because I don't deal in these areas, it's important for that reason for all agents to be aware of it. And it's also important because this is a pilot program, and there's a possibility that it could extend to other wards if the city council at some point determines that they feel it was successful in meeting their objectives. That concern could spread to their wards, and so it's important from a political standpoint to be involved, from an industry standpoint to be involved in this.
The Northwest Side Preservation Ordinance also amended the demolition surcharge ordinance that passed in 2021. Can you explain the amendment to this ordinance and what that means for developers and investors?
In a very simple nutshell, it quadrupled the demolition permit fees for single-family townhome and 2 flats, it went from $15,000 to $60,000, and for all others, it went from $5,000 a door to $20,000 a door. So what that means for developers is that's a huge cost that they have to add to factoring in whether or not they want to apply for a permit. It only applies if you are applying for a demolition permit in the zone. The purpose was to help the city's fund for maintaining and preserving and even building affordable housing, so that's where the additional money is supposed to go. The expansion of this ordinance was based on the notion that, well, in the past it was very successful in preserving affordable housing because these development permit applications dropped by 81%, but then there's the flip side. If it's dropping by 81%, you're not really collecting revenue, so questionable whether it's actually successful, but that is the objective. That portion of the ordinance not only applies to the 5 wards that we talked about before, but also includes Pilsen. That's where Pilsen comes into this particular ordinance. The demo fees apply there as well.
Since you're the expert, and I believe everyone should know about this ordinance, how can a real estate agent get in contact with you if they have any questions?
For me, most effective is email, jerwin@erwinlawfirm.com, that's with an E, or you can call my office, 773-525-0153. Happy to answer questions. Again, email, because I can answer at all hours and weekend and stuff, and for these things, I'm happy to give educational information on it because it's important.
Well, thank you so much, Jim, for being here. I appreciate you answering these questions. I hope this clears up some confusion for all the people wondering. We will see you next time.